Hey there. Here at Gossip Without Prejudice, we are very familiar with how uncomfortable it can be to go through a legal battle. That's why we're very happy to be partnering with the Hemmat Law Group. They've been practicing for over 35 years and are recognized all over the country. If you're connected to Washington State and need some assistance, please visit hemmatlaw.com. That's HEMMAT law.com. Thank you.
Welcome back. Main story of Gossip Without Prejudice. Lindsay, how are you feeling this week?
I'm feeling great. I don't know what we've got going today. John is going to present our story to us today.
Yes. So this week, we are digging into a little bit of a double prosecution snafu. So everyone is familiar with double jeopardy, where the government, generally speaking, cannot charge you for the same crime twice or repeatedly to try and get a verdict that they like. It's a one and done system. But what happens when prosecutors charge two people for conflicting, mutually exclusive sets of facts and then convict them both?
Ooh, okay. So wait, let me make sure I understand here. So like a bank gets robbed, there's two different suspects and both of them are tried?
Well, both of them are tried as the lone, to use the metaphor, both of them are tried as the lone burglar.
Wow.
And they both can't be the one who done it because by definition,
literally impossible.
So what the government has started doing in recent years is trying two people for the same crime and convicting them both. But in this case, it was a gun charge. So let's get into it.
Okay.
Before we start, please hit all the good buttons, like, share, comment, subscribe. Only about 70% of you listen all the way through to all of our content, which is actually pretty high for a new podcast. But most importantly, we need more visibility to help grow our audience, grow our exposure, and keep all of our work free for everyone forever. Pledge as low as $5 keeps us on the airwaves. So any support you could offer us would be fantastic. Reach us at gossipwithoutprejudice.com. Submit your stories, comments, and feedback. We'd love to hear from you.
Yes, indeed. Thanks for listening.
Yes. Jumping into the story.
Let's get into it.
This is going to be taking us back to January 2014.
Okay, going back a decade.
So at around 11:10 a.m. on January 2nd, 2014, Baltimore police pulled over 22-year-old Keyon Paylor for a weapons violation. Plainclothes officers in an unmarked car spotted him quickly walking down Bartlett Avenue, according to Detective Daniel Herzl.
Okay.
Once Paylor noticed the car, he picked up his pace, ran onto a porch, and, after hopping over a short retaining wall, reached into his waistband with his right hand, pulled out what looked like a black handgun, and hid it under a chair cushion.
Ooh, that's pretty sus.
The officers then arrested him inside the house, and during their search, they found a small amount of marijuana on top of the same cushion. When confronted, Paylor responded, "The weed's mine. I don't know nothing about the gun." Quote.
Okay.
A word on Herzl. He was notorious on the streets of Baltimore. A rapper by the name of, this is true, a rapper by the name of Young Moose called out the officer by name in his song, "Fuck the Police."
Nice.
We actually have a link in show notes. In a first-person account, a University of Baltimore professor would later call Herzl arguably the most hated cop in Baltimore.
Wow.
And we're going to get into why.
Okay. Oh my gosh. Okay.
Paylor,
our man who was arrested.
Yeah, who was arrested, wasn't his first run-in with the law. He had previous convictions for controlled substance charges and for possessing a firearm as a minor. His case was moved to the U.S. District Court for Maryland, and on June 4th, 2014, a federal grand jury indicted him on a weapons possession charge as a convicted felon.
Wow.
So he got the charge got amplified by his prior history.
Wow.
He was also, goes without saying, African American.
Thanks, Baltimore.
Yeah, and Detective Herzl is also a white man.
Okay.
So just added context to the story.
Thank you for the context.
And the history between Paylor and Detective Herzl went way back, dating back to when Paylor was just 13.
Really? And he was 22 at that arrest.
At this arrest. After an early arrest with Herzl and his then partner accused him of having heroin, though he was later acquitted at trial. Herzl and Sergeant John Burns, another officer involved in the incident, had also been connected to other charges against Paylor, specifically.
Okay, this is a little too personal for my liking.
While in jail, Paylor even told his family that the officers had taken several $1,000s from him during the search, and he maintained the gun wasn't his, saying, "They didn't see me put no gun nowhere." So basically what's happening is we have a personal history between the officers that arrested this gentleman who does have a documented history of involvement with the system, but has both been successfully convicted of and acquitted of various serious charges before. But there is some history here, one way or another.
I can't imagine that no form of a relationship with that police officer is going to be good, I think. Anyone who has a history with that officer is going to hate him, is what I'm trying to get at here.
I mean, and over-policing in a lot of neighborhoods is a serious problem.
Yeah.
Brendan Herson, a federal public defender representing Paylor, filed motions to suppress the evidence, which is to say the weapon and Paylor's statements, arguing that Herschel and his team didn't have enough probable cause for the arrest to begin with. So you need probable cause to effect an arrest and search. We have protections against unreasonable searches and seizures, and so you need an articulated reason why you are searching or detaining this person, generally speaking.
And so in this case, it was the officers witnessing him putting the gun under the cushion,
Well,
right?
hold that thought.
Oh.
Herson also built a case based on what he described as a pattern of misconduct by Herschel. Herson is the public defender.
Herson and Herschel.
Yes.
Got it. Okay.
Yeah.
Herschel.
Brendan Herson.
Herson is the
good
attorney, the good guy.
Yes,
okay, and
he's
Herschel
the defense attorney.
Is the officer.
Yeah, the defense pointed out that Baltimore had paid nearly $200,000 to settle a lawsuit accusing Herschel of using excessive force, and even alleged that Herschel had submitted false information on search warrants previously. Herson argued that Herschel, a white detective, showed extreme bias against young black men like Paylor.
Oh, come on, man.
Even though prosecutors initially fought Herson's request for more information, which is to say discovery, they eventually handed over 30 internal affairs files on Herschel and other officers to Judge Ellen Hollander.
30 seems like a lot.
Well, on April 9th, 2015, Judge Hollander ordered that only 4 full files, plus part of a 5th, be released to the defense. So the court ruled that, in its opinion, calls balls and strikes, that's what a judge is supposed to do, is that relevant to this issue, only 4 and part of a 5th should be released to the defense. And so the problem is that this basically hollowed out the misconduct, because you have to build a case of repeated patterns, and the defense did not feel this was enough. So shortly after that, on April 21st, 2015, Paylor dropped his motion to suppress the evidence and pled guilty.
Oh, man.
I mean, he didn't
really have any other choice.
Yeah, because without support of the full misconduct record, it just wasn't enough to mount to defense. And at that point, it was better to plead out, get a lesser charge.
So can I jump in with a question?
Sure, yeah.
Why would the judge remove most of those cases? Says they weren't relevant?
The argument was that only the ones related to Paylor, directly or indirectly.
Oh, really? Okay, so it wasn't about showing Herschel's character. It was only about showing the relationship between these two men.
Well, yes and no.
Oh,
the judge just didn't feel all these other cases were relevant.
Okay.
TLDR. There was a lot of spilled ink on this issue. But basically the court said that only these are germane to this issue, so we're only handing over a small number of them. Herson later admitted that the limited evidence didn't really help challenge that the officer might say about the arrest. Before the plea, a prosecutor had laid out that officers saw Paylor remove a Heckler and Koch 45 caliber pistol from his waistband and hide it under the porch cushion. When Judge Hollander asked him if that was an accurate summary of the case, Paylor simply answered, "Yes, ma'am," twice. And he was sentenced to 5 years in federal prison.
Oh, wow.
However,
it doesn't end here.
In 2017, in February 23rd, 2017, a federal grand jury then indicted Herschel and 6 other Baltimore police officers on wide-ranging corruption and misconduct charges, including theft and falsifying reports, just like Paylor reported.
Woohoo!
Yes, as part of an investigation into the Baltimore Gun Trace Task Force, GTTF, terrible acronym, a unit formed in 2007 to take illegal weapons off the street. Herschel had joined this unit in 2016. Yeah, so basically there was a massive corruption bust. Falsifying reports, theft from suspects, theft of the public record, abuse under color of law.
Thank goodness they got persecuted for that.
Well, here's what's coming. FBI agents had listened to Paylor's phone calls from jail, and because his allegations echoed issues raised in other indictments, prosecutors reached out to his lawyer for more details. In an interview in June 15th of 2017, Paylor said that on the morning of his arrest, he'd just seen his probation officer, which meant going through a metal detector. While walking home, a friend warned him that the police were behind him. Paylor reassured his friend that he wasn't doing anything wrong. He also claimed that officers took between $4,000 and $5,000 from his second floor bedroom, and he watched as Sergeant Burns rifled through his belongings needlessly. So basically, when they made the arrest, they took a bunch of money, didn't report it. Shortly thereafter,
Piss me off.
during his grand jury testimonies, because he was testifying at Paylor's at Hersl, Paylor was testifying at Herschel's grand jury indictment as one of the witnesses, described how Hersl and two other officers were searching him while Sergeant Burns was upstairs in his room tearing it apart until money was found in a drawer.
Disgusting.
Well, it's interesting because I used to work with a lot of vulnerable communities. They don't trust the system, and so keeping a large amount of cash is less unusual than it might seem. Right? It's like, who has $5,000 in their sock drawer? And I'm like, well, people who don't trust the banks or anyone associated with them.
I was talking about that recently, and that can be kind of a generational thing. Like if you go back to the Great Depression, no one trusted banks, and slowly over time we've regained trust, but definitely not everyone. So not surprised.
They then took him outside, cuffed him, and showed him the chair cushion along with the pistol. Paylor insisted, "Man, that's not my gun," even as the officers argued they'd seen him place it in there. In the end, he said he pled guilty simply because he thought it was the best way out of a bad situation.
Yeah, he felt like he had no choice.
Now, here's further along. After his testimony, the grand jury brought about a superseding indictment against Hersl. So something to note about criminal indictments, you can't amend an indictment because it creates a moving target for the government. So instead of amending indictments, you just issue a brand new, what's called a superseding indictment.
I see. And that invalidates the previous one.
Yes, exactly. So it still is a fixed target, but it shuffles the old one out of the way. That's for constitutional reasons we don't have to get into now. That's why that's where the term superseding indictment came from.
Good
so
to know.
brought out a superseding indictment against Hersl on July 5th, 2017. Prosecutors even filed a motion under Rule 35 asking for a sentence reduction for Paylor in exchange for his cooperation with the GTTF investigation.
Yeah, I feel like he would deserve that.
But he turned it down.
Oh, really?
Fearing police retaliation in prison. A federal jury convicted Hersl of racketeering, robbery, extortion, theft, and assault on February 13, 2018, and he was later sentenced to 18 years in prison.
Yes! One for the system!
During his trial, prosecutors claimed Herschel's misconduct. This is all just set up. This isn't the story.
Oh my goodness.
Prosecutors claimed Herschel's misconduct had been going on for years before the 2014 incident. Then,
surprising.
On March 12th, 2018, now with Gail Horn from the Exoneration Project at the University of Chicago Law School representing him, Paylor moved to vacate his conviction entirely. His argument was that he'd pled guilty without knowing how extensive Herschel's misconduct was. His motion pointed out there is now reliable evidence that since at least 2014, before Mr. Paylor pled guilty, Hersl had been committing crimes against and violating the constitutional rights of some of the most vulnerable and marginalized members of our society. The government pushed back, saying that Paylor had repeatedly confessed his guilt, and there was no failure to disclose any evidence since the lawyer was aware of Herschel's past behavior at the time. Which they kind of were, sort of, because they did have a motion to get all of his misconduct records. But the new appeal is that they just didn't know it went even bigger than that. Which, in my opinion, that is kind of a weak argument, in my opinion. But that being said, the interest of justice here is extremely clear. Now, here's what Judge Hollander did. Without an evidentiary hearing, Judge Hollander denied Paylor's motion on November 22nd, 2019, arguing that there was no disclosure violation because the GTTF investigation didn't start until after Paylor's guilty plea. So there was arguably nothing to disclose.
Okay.
By that time, Paylor was already out of prison, having been released on May 11th, 2018.
Okay. Wow. So that was long after.
But still, he's fighting this for, it's the exoneration projects or do this sort of work for public interest reasons.
Beautiful.
Now, during oral argument before the Fifth Circuit Court of Appeals, prosecutors tried to spin by saying that Paylor's plea was truthful while casting doubt on his grand jury testimony. So they're trying to talk out of both corners of their mouth here. When Judge Stephanie Thacker pressed them, one of the appeals judges, asking if it was acceptable to have someone testify differently under oath than they confessed in their plea, the prosecutors dodged a clear answer, eventually admitting that the government had looked into Paylor's claims after his testimony and found them untrue. So basically they're like, how can you testify before the grand jury on Hersl saying that hey, he hid this gun under the couch cushions, while also accepting his guilty plea in separate proceedings that, hey, I hid this gun under the couch cushions. Both those things can't be true.
I see.
Right? And so the appeals court was like,
what a mess.
guys, what the prosecutors are, you can't have your cake and eat it too.
Yeah.
On December 15th, 2023, so this is still ongoing,
Okay.
the appellate court vacated Judge Hollander's order and sent the case back to the U.S. District Court for further discovery and an evidentiary hearing.
Wow.
In its opinion, Judge Thacker famously stated, "There cannot be two sides to the truth. The truth is the truth." The court also criticized the government's inconsistent timelines about Herschel's misconduct, claiming that their statements at Herschel's trial and in legal briefs were completely at odds, saying the government, quote, two-faced positions were simply incompatible with justice.
Yikes.
Although Paylor hadn't yet presented enough evidence to withdraw his plea, the court ruled he deserved a chance to gather that evidence and present his case.
Okay. So he's been given a second chance to re-examine this.
Yes.
And so still his ultimate goal, right, is to get that guilty charge or get the case vacated and off his record.
So on February 7th, 2024,
Okay.
just around a year ago,
Okay.
Judge Hollander, back with the original judge, who was kind of dickish the first time, we go Judge Hollander, enemy of the podcast, ordered all parties to complete discovery within 90 days. So which is to say, during criminal proceedings, the defense has a right to all exculpatory evidence. Now, the judge, like Judge Hollander did here, can weigh in and say this evidence is relevant, this evidence is not. Failure to hand over duly owed exculpatory evidence is called a Brady violation. We should do an entire episode about that. In fact, there was a major Brady violation that was in the news the other year. I think there was like a prosecutor who failed to hand over a bunch of evidence, and you can get a mistrial, but more often you get a dismissal with prejudice and you just lose the entire case. The government, that's why the government always hands over exculpatory evidence.
That's a serious gamble that you're taking there if
and
you decide.
With prejudice means it cannot be refiled. So basically the government loses its chance.
The charges are gone. You just can never file that again.
Yes. So Judge Hollander ordered all parties to complete discovery. Just a few weeks later, on February 28th, 2024, the government agreed to vacate Paylor's conviction.
Wow.
Acknowledging for the first time the conflicting accounts of the arrest. So rather than fight it, the government, once faced with the reality that it would have to fully disclose on the record, they just gave up. They said, we can't do this.
All right.
Yes.
Screw it. We're going to stop trying.
Now, the filing noted that although Herschel had written the incident report, he had been convicted for, quote, although Herschel had written the incident report, he had been convicted for a pattern of, quote, misconduct similar to the behavior alleged by Paylor shortly after the indictment and during Paylor's testimony to a grand jury. And finally, Judge Hollander granted the motion to vacate on March 3rd, 2024. And on March 6th, 2024, she dismissed the case entirely.
Wow. Okay. So it's all done with now.
Yes.
Paylor is free and he is not guilty of that crime anymore.
So we're only about halfway through this story.
Oh my God, what?
so this is a serious case with serious misconduct issues, but it's actually a pattern. So either Paylor hid the gun in the couch cushions that the police found, or the police planted the gun and framed Paylor.
Right.
Those are the only two possible things that could be happening here.
Yes.
Both two things cannot be true.
Right.
Even so, the U.S. Department of Justice presented the first version while convicting Paylor of being a felon in possession of the firearm, then presented the second version as true while prosecuting the corrupt police detective who had arrested him. And they both got convictions. So both people were convicted of the same it's not double jeopardy because you're instead of trying one person for multiple crimes, you try two people for separately. Similarly, there's actually a similar case in 2019 called U.S. v. Driggers, a case involving a gun stolen from a train in Chicago. The defendant, Nathan Driggers, was convicted of being a felon in possession of a firearm. Similar story. Okay. I actually did not confirm whether or not this gentleman is African-American, but chances are good. When prosecuting a co-defendant named Warren Gates, the federal government contended Gates bought the gun from the train robbery from two other men. But then in trying Driggers in separate proceedings, the government contended Gates bought them from Driggers.
Ooh, that's not okay.
So they did the same thing here is either one guy bought the gun from the other guy or the vice versa. And
you said this was Chicago?
Yeah, this was in Chicago.
Okay.
Nathan Driggers and a gentleman named Warren Gates. So one of them had to have bought the gun and brought it. Right.
But the government is saying that both of them bought the gun. And
from both of them. Yes, exactly. And convicted both of them. In a 2019 opinion, the government and the courts wrote, the government has not explained to us or to anyone else how these two conflicting factual representations can clearly coexist, and we are at a loss to reconcile them.
Mhm.
And then the court upheld Drigger's conviction.
Okay, wow. So the complaint was raised, the court looked at it and said, nah.
Well, no, the court said, no, this is wrong and terrible, and then let it stand. And this actually isn't an aberration. So a ProPublica journalist writes, quote, prosecutors presented shifting theories in which defendants stabbed someone or chopped someone's skull or held someone's head underwater. Most cases involved a gun. Prosecutors would say one defendant fired a fatal shot. Then, in a separate trial at later proceedings, before a different trier of fact, say a different defendant fired it.
And they can basically get away with it because it's a different trier of fact, and
Yes.
they haven't looked at the previous one.
Mm-hmm.
Oh, man.
Now, in 2009, in Lynn, Massachusetts, a state prosecutor argued that Bonad Salk fired the single shot that killed a man outside of a restaurant.
Okay.
6 months later, in a separate trial, the same prosecutor said the shooter was actually Kevin Keyon. Both men were convicted of the same shooting.
This is way more common than I did not expect you to have 3 examples of the same exact thing.
In Stuart, Florida,
Wow.
a convenience store clerk was
here's
shot.
number 4.
A convenience store clerk was shot and killed in 1982. In a first trial, the prosecution argued John Earl Bush was the shooter. At a second trial, the government argued Alfonso Cave actually done the crime. At a third trial, it argued J.B. Parker was the same shooter. All 3 men were convicted and sentenced to death.
What? All 3 of them?
At least 29 men have been sentenced to death in the U.S. since 1970 in cases where the prosecutors were accused of presenting competing versions of the truth.
Repeat that sentence again, please, because you said death.
Yes. Oh, in Stuart, Florida case? Yes.
This last, 29 people have been sentenced to death.
Yep.
In cases like this where there's conflicting
Since the 1970s, yes.
That's so many people. Wow.
Mm-hmm.
I had no clue that there was such a massive flaw like this in the system.
The U.S. Supreme Court has never ruled squarely on whether the conflicting prosecution theories violate due process.
Of course it violates due process.
Lower courts are divided. In a handful of cases, a court has overturned a conviction of a death sentence, finding the prosecutor's contradictory statements to be fundamentally unfair. But more often than not, courts have allowed the tactic, even as many have described it as unseemly or worse.
Yeah.
In a perfect world,
Oh.
now here's where I want to add commentary.
Okay.
In a perfect world, bar associations are supposed to step in to rein in prosecutorial misconduct. But nationwide, we see an alarming pattern of inaction by the judiciary, even as they proclaim individually of a trend of injustice where the truth is not always enough. And this is why I wanted to involve the bar here, because the bar can step in independent of court referral and stop this.
Mm-hmm.
But we see prosecutors acting like monsters all over the place because they can get away with it.
Mm-hmm.
And otherwise, there's tremendous prosecutorial immunity. It's very hard to pierce prosecutorial immunity. I would argue for good reason, but there's supposed to be limits to that, and we're not seeing them.
Wow.
Thoughts?
I'm a little bit mind blown over here that this is how it is. So are there any, do you know, maybe you don't know, are there any cases of the bar getting involved in one of these?
As far as I can find, no.
No.
Not specifically for this reason.
Do you think there's any way the bar could have a vested interest in not prosecuting these prosecutors who've done this?
Stretch for resources,
Stretch for-
apathy.
yeah.
These are usually with poor people with no resources, people who
sure.
are in minority populations.
So potentially the folks who are victims in this situation aren't even reporting this to the bar because they wouldn't know how to do that, and then 2, how would they know? Wow.
Yeah, and we're still not done.
Oh no.
Ken Armstrong, the ProPublica journalist we were relying on
Thank you,
heavily. Ken Armstrong's work is fantastic.
Shout out.
He wrote, quote, I wanted to ask the various prosecutors in this matter about the Fourth Circuit's opinion lambasting the government. I emailed Martinez, who was one of the prosecuting attorneys involved in a case like this,
Okay.
who left the Department of Justice and now works for a large law firm. He emailed back saying, quote, as I understand the relevant DOJ regulations, I am prohibited from speaking with you absent authorization regarding the work I did in the United States Attorney's Office. Quote. Separately, Justice Department emailed Ken, saying, quote, "We are not commenting on this case, nor are we authorizing Mr. Martinez to comment." So this is in regards to. I should restart this section because this is about Paylor's case. I should.
Okay.
Let me
I
start
wasn't
over.
quite following
Yeah.
there.
That was my bad.
Cool.
So in regards to Paylor's case,
Mhm.
Ken Armstrong is the journalist with ProPublica, a fantastic nonprofit newsroom we use to do a lot of our research.
Thank you, Ken.
I wanted to add he wanted to talk with some of the attorneys and prosecutors who did this
Yes,
to Paylor,
please.
and also who prosecuted Herschel.
Mhm.
Now he wrote in his article, quote, "I wanted to ask the various prosecutors in this matter about the Fourth Circuit's opinion lambasting the government.
Mhm.
I emailed Martinez, one of the prosecutors involved, who left the Department of Justice and now works for a large law firm. He emailed me back saying, as I understand the relevant DOJ regulations, I am prohibited from speaking with you absent authorization regarding the work I did in the United States Attorney's Office." End quote. Now, the Justice Department separately emailed Ken saying, "We are not commenting on this case, nor are we authorizing Mr. Martinez to comment."
So Martinez forwarded the email to the Justice Department there. And
No,
said,
Ken reached out separately.
Okay, I see,
Yeah.
I see.
And then Ken asked, "Hey, Mr. Armstrong asked, can I speak with Derek Hines and Leo Wise, like these other guys I
Yeah,
know about?"
please.
And they wrote back, quote, "Department guidelines generally prohibit commenting on pending cases. Therefore, Wise and Hines are not authorized to sit for an interview. Thanks." Quote. The Justice Department responded. Wise and Hines are now both working on the DOJ team prosecuting Hunter Biden at the time of this article, the president's son, on gun and tax charges.
Huh. Wow.
Herschel asked in fall of 2023 to be released early from prison on grounds of compassion.
No.
An emergency motion said Herschel had been diagnosed with metastatic prostate cancer. A doctor in September wrote that Herschel's life expectancy is less than 18 months.
Okay, yes.
Yeah. DOJ opposed the motion, noting, among other things, that Herschel had shown no remorse, continuing to maintain his innocence, and a judge denied Herschel's request.
All right. The showing no remorse and continuing to maintain innocence. That's how, yeah, no, don't let him out.
Herschel was represented at his trial by William
This sounds like an interesting one.
Purpura.
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 Purpura. Okay, let me restart that sentence.
Beautiful.
Blake, edit. Herschel was represented at his trial by William Purpura. Purpura, in an interview with ProPublica, said he once asked Herschel if he ever planted a gun on anyone. Herschel laughed and said no, that in Baltimore there was no need to put a gun anywhere. Yeah, so yeah, this guy was a real piece of shit, honestly.
Wow.
Yeah, so the current state of affairs is that all the prosecutors remained employed. No one faced any consequences.
No one's allowed to even talk about the fact that they did that.
Yep.
So, oh Lord Almighty. So I'm want to dig into why can't the prosecutors talk to press about this?
Well, this is on one hand, there's a compelling public interest for this because you don't want prosecutors just talking to the press.
That's true.
About ongoing
the confidentiality, but these aren't ongoing, right? These
Well,
are all concluded.
Even then, you don't want attorneys just like talking about cases,
Yeah.
especially at the level of the federal government. It's just
Mhm.
messy. I don't think it's a good look for the government to constantly be like taking newsreels,
That makes
which
sense.
is actually one of the reasons why I really fucking hated. We haven't talked about this before, but the prosecutors. Or not the prosecutors, at least the police, the police commissioner, and a bunch of other people in New York sat down and actually did like a biop piece on Luigi Mangione while his charges are pending. And so there's actually a motion to suppress. There's actually a motion right now. I don't think that's been ruled on yet because Luigi's defense attorney is like, hey, you guys are out blabbing and making assertions about stuff that has not yet been proven, and it's incredibly prejudicial to the potential jury pool.
Yikes.
We should do an episode on that, but the New York prosecuting attorney's office is doing some weird stuff right now when it comes to the Mangione case.
Wow. Yeah. Let us know if you guys would be interested in hearing about that case.
Yes. I have held off on doing a full episode on it because so much of the conclusion it'll come later. Right now, Luigi is mostly just sitting in jail waiting for his day in court.
Yeah, waiting for his lawyers to do all the dang work.
Yes.
And it's going to be a while until we have a full answer on that. So maybe once the Luigi Mangione trial is done, maybe then we'll dive into it. If you guys would like.
We'll put it to a vote of our community. If you want to weigh in on what future content we're going to be covering, go to our website.
Yes.
You'll find all the details there. You'll figure out how to join the community, pledge of $5, blah 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 blah. But I don't like seeing the government do stuff like that.
No, to me, this feels deeply shady and underhanded in the worst way that I would expect my government to be.
Yeah, and I think that's this is why I say that the most important person in any jurisdiction is the prosecuting attorney. This is the federal government charges, but even so, who picks the prosecutors has way more of an impact on the local community than people think. We don't really have like if you think about it, police misconduct in this country are universally, all the horrible stories are universally areas controlled by Democrats. So have you ever thought about that? Like you never hear, I'm sure there's misconduct out in rural areas, but you never hear about like Kenosha County Sheriff, horrible systemic repression of Black African Americans. It's all these places are actually already under the most change-minded people's control. And one of the big reasons cops get away with this is because the prosecutors bring charges on anything they tell them to, right? And so police would feel way less empowered to shoot people, to arrest people for bogus charges if they got pushback from the prosecutor's office saying, hey guys, this isn't good. We shouldn't do this anymore. But they don't. And so police run free. I think the police misconduct issue is a lot easier to solve than we think because it all starts and ends at the prosecutor's office. That's the filter, right? But right now there's no filter, and so all we blame are the people on the streets doing it, and that's the police.
Wow. Do you think that a federal solution could fix that, or
Well,
do you think it needs to be more state by state?
There are things called consent decrees. So
Okay.
Seattle was actually, with the Trump administration, is actually currently working on canceling most of them. Consent decrees are when shit's gotten really bad, a federal court will step in and set up like a reform plan.
Okay.
And it's imposed on usually local jurisdictions like SPD here in Seattle, like Minneapolis, where it's George Floyd. They MPD had a consent decree entered against them. A couple of other places, Breonna Taylor, etc. Those are the exceptions, but they exist. So the feds actually do step in when things get really bad. They have their problems. They're difficult to enforce. They maybe don't bring about the change they need.
And I haven't heard of them.
And you haven't heard of them. And even then, I am dubious about the federal government dictating local police.
Yeah, that's tough.
Yeah.
The variety amongst local police is infinite.
Yep.
And so how can we, that's touchy.
Well, police don't face civil, like legal challenges that often. They can face like job related, like department policy, but department policy can be anything. They often don't face like legal trouble for misconduct. Here, I wish I had a more happy like takeaway. The takeaway of this story is that you should be aware the government is doing this.
Yes.
You should not trust the police. We should do an entire episode specifically on police misconduct. We have a potential episode on how police undermine criminal justice reform that prosecutors try and put in place. So rest assured the police are complicit in this stuff like this. But the sense of injustice and rage I get knowing that this stuff exists, there are actually even cases in the federal judiciary where literal proof of innocence is not enough to overturn a conviction. Episode for another time.
Oh man.
Yes, I know.
That's some real angry stuff right there.
And so people are always like, oh, if you have nothing to hide, you have nothing to fear. You have a lot to fear.
You have a lot to fear.
Yes.
Whether or not you're innocent, you could be a victim of the system. That's what we've learned here today, folks.
Yes.
My God.
Lindsay, any final wrap-up thoughts?
Don't get legal advice from a podcast, folks. Whether it's this one or any other.
Well, I think I wanted to add that we know about this is the important part.
Yes, that's true. That we're able to communicate about it and let people know that this is happening.
Yes. Talk to your senator. Get involved in local politics. Local politics have more investment in your day-to-day life than the feds do.
That's for sure.
Thank you for joining us for another week.
Yeah.
We really appreciate the time you took to share this moment with us, as unfun as it was.
Yeah.
I'm thinking about a story about Castle Rock v. Gonzalez. We'll see if we actually end up doing it. It's maybe where police have no duty to help you even when you have a court order saying you're entitled to it. I know.
I got feelings about that one.
I know, but we will be following up in the coming weeks. Thank you so much for joining us, guys.
Wow. Thank you so much for listening. We'll see you in the next one. Bye.